non-qualification of second respondent on grounds of his alleged criminal conviction, forgery of documents, and dual citizenship. That is foul play, which paragraph 16 sub 1A to the first schedule of the Electoral Act expressly forbids. Consequently, paragraphs 1B, 1, Roman figure 7, A, B, C, and Roman figure 8 of Part 1, as well as paragraphs 2, 3, Roman figure 1, 2, 3 of Part 2 of the reply of petitioners. Second respondent, wherein petitioners avert new facts of purported criminal conviction for future proceedings against second respondent adverse to his purported dual citizenship or grounds of non-qualification, are all hereby struck out. Paragraphs 8, 11, Roman figure 1, 24, and 24b of the petition we hold on the state of the authorities earlier considered are also new facts or at best mere denials and so liable to be struck out too, as they do not qualify as replies. Bearing the above, all other paragraphs of the petition filed on the 23rd, petitioner's reply filed on the 23rd of reply 2023 stand either not objected to or the complaints against them are not made out. In other words, the application of second respondent also succeeds partly as stated above. Third respondent's application as relates, and now we come to the third respondent's application, and we come straight to say that I find necessary to first observe that, like all other replies of the petitioners, the impugned reply of petitioners of 24 that was served on third respondent is in parts A and B. Part A is devoted solely to the preliminary objection raised by third respondent's reply to the petition. That part is understandably not challenged by third respondent, so it shall remain as it is. It is only part B of that reply that is challenged by third respondent, and it's also this part that contains in its paragraphs 32 and 33 the fresh facts of second respondent's alleged status as ex-convict and having dual citizenship, all of which now insist disqualified him as a candidate for the election. These facts I have already determined can only be raised in the petition and not in their reply to the respondent's reply to their petition. They therefore offend paragraph 16A stated above. Besides these two paragraphs, every other amendment in paragraph 2 of the reply, bar last paragraph 35, are, as third respondent's counsel rightly pointed out, either mere denials of third respondent's reply to the petition or repetitions of petitioners' averments in their petition, and so not permissible in a reply as per paragraph 16AB, 1A of the first schedule of the Electoral Act. See again, cited cases. It's also not the law, as erroneously argued by petitioner's counsel, that failure to reply to facts averred by third respondent in his reply to the petition would mean admission of those facts. Somehow, counsel like arguing always like that, not just this one. Failure to deny averments contained in a statement of defense does not imply admission, like it does with failure to deny averments in a statement of claim. See against Simba's case, Ayola GSC, I cited the summary third respondent's application succeeds in its entirety. Consequently, barring paragraph 35, the entire part B of the reply of the petitioner's reply of third respondent is incompetent and is hereby struck out. That concludes and settles all 7 applications trust preliminary objections of respondents. So that is it. So I now hand over to my leader, as politicians who want to call it, so that my Lord can continue from there.
We'll go to the respondent's objections to documents tendered at the trial. My learned brother, by my immediate right, read the ruling.
Thank you. We want to take on the respondent's objections to documents tendered by petitioners at the trial. In the course of the hearing of this petition, objections were raised by the 3 respondents. First, to the validity of the witness statements on oath deposed to by some of the witnesses of the petition. Specifically, PW12, that is petitioner's 12th witness, Eguma Friday. PW13, that is Grace Timothy. PW14, Grace Ajagbona. PW15, Abidemi Joseph. PW16, Ms. Edosa Obasa. PW17, Ms. Aleri Ayuba. PW18, Ms. Sadia Mohammed Haruna. PW21, Mr. Samuel Odunta, the statistician. PW23, Janet Nuhu Turaki. PW24, Christopher Bulus Ado. PW25, Victoria Sani. PW26, Hitler Egwonu Nwala, the forensic expert. And PW27, Mr. Mike Enahoro Eba, a legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties. The ruling on it deferred by the court till final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents. I now proceed to consider the said objections of respondents. 1, the validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, that did not accompany the petition as required by paragraph 45E of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by First Respondents' Counsel on 8th of June 2023, when PW12, Mr. Eguma Omachono Friday, the presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June 2023, long after the filing of the petition, and even after hearing of the petition had commenced, Respondents' Counsel again raised and adopted the same objections against those witnesses and their witness statements. As explained earlier, the thrust of the objection, which was championed by Chief Wale Olanikwekwe SAN, for second respondent, was anchored on paragraph 45B of the first schedule to the Electoral Act 2022, requiring that the election petition shall be accompanied by, among others, witness statements on oath of the witnesses the petitioner intends to call in proof of the petition. Learned Counsel argued that insofar as the witness statements on oath of the said witnesses of the petitioners did not accompany the petition of petitioners as required by paragraph 45B and 6, sub 6 and 7 of the first schedule to the Electoral Act, they were incompetent and cannot be relied on by petitioners or the witnesses concerned. It is irrelevant. Counsel argued that the said witnesses came to testify on subpoena issued to them by this court as paragraph 45B of first schedule to the Electoral Act makes no distinction between ordinary witnesses and those who were testifying on subpoena. Then that argument was taken, and after hearing the argument, this is our resolution. Now, this contention of the respondent has far-reaching consequences, as its resolution in favor of respondents will result in the court discountenancing the evidence of all the presiding officers, namely PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who were in the polling units in the election and so were eyewitnesses to the alleged failure by INEC to transmit and uphold the election results to IREV, major pillar of the petition. It will also result in discountenancing the evidence, oral and documentary, presented by petitioners' two expert witnesses, PW 21 Samuel Odunton and PW 26 Hitler Nwala, but also their last witness, Mike Enaoroeba, PW 27, who alone testified on the non-qualification of second respondent for the election and tendered documents in that direction. That is, even as we must not fail to remind ourselves that the relevant facts in the petition and replies of the petitioners that would have supported the evidence of PW 21, 26, and 27, Mr. Samuel Odunton, Hitler Nwala, and Mike Enaoroeba, have already been found incompetent and struck out by this court while ruling on the applications like preliminary objections of the respondents. Coming back to the objection of the respondents that paragraph 45B of the first schedule to the Electoral Act 2022 does not make any dichotomy between ordinary witnesses and those testifying only on subpoena as regards the duty to front-load witness dispositions along the petition. So the evidence of PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, whose witness statements or notes were not front-loaded with the petition are incompetent. Paragraph 45B of the first schedule to the Electoral Act 2022 reads thus, and I want to mention it. It says the election petition shall be accompanied by B, written statements on oath of witnesses. And clearly, this provision, particularly the word witnesses, whose written statements on oath the lawmakers require that shall accompany the election petition, must be given its literal interpretation. See the recent decision of this court in Ogba and Vincent, and then that of Senator Ararumi and INEC, all citations supplied. The unreported decision of this court also of 17th of July 2020 in Advanced Nigeria Democratic Party ANDP, versus INEC and two others, appeal number EPT 406/2020, and People's Democratic Party versus Okogbo, citations supplied on the issue. Where the words of a statute or instrument are clear, like paragraph 45B of first schedule to the Electoral Act is, particularly the unqualified witnesses, in quote, employed there, the court has no duty than to give it its literal meaning. Now, in Advanced Nigeria Party, Democratic Party MP versus INEC, in appeal already cited, presided over by Justice Igenimpa and Agim, our colleagues, as Agim as he then was unanimous in his decision on the point in issue. IGJCA, pronouncing the leading judgment, said, I am of firm view that if Section 145 of the Electoral Act 2010 and paragraph 34554 of the first schedule to the Electoral Act 2010 are juxtaposed with Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, it is eminently clear that Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules is outrightly inapplicable to the situation the appellants find itself in this case. Paragraph 3 and 4 of the first schedule to the Electoral Act 2010 contain express and adequate provisions as to what the contents of a petition should be and the documents that must be front-loaded and accompany an election petition, including a list of witnesses that the petitioner intends to call in proof of the petition, and more importantly, written statements on oath of witnesses. Well, there is also, it says further, there is no dichotomy between witness statement mentioned in paragraph 4.5 of the first schedule to the Electoral Act in respect of witnesses' statement on oath of witnesses and witnesses' statement on oath of a subpoena witness. There is no distinction between ordinary witness and subpoenaed witnesses under paragraph 4.5 of First Schedule to the Electoral Act. In essence, paragraph 4.5 of First Schedule to the Electoral Act covers witness statements on oath of all categories of witnesses the petitioner intends to call at the trial of his or her petition, unquote. In Senator Ifeanyi and INEC, this court also decided over by my Lord Justice Tsammani, JCA, the concurrence of my brothers Owade Kimbami, Bolaji Yusuf, and Bayero JCA, again confirmed this position when in that decision was held. Learned counsel for the appellant has argued that PW2 was before the court on subpoena, therefore the tribunal could not turn around to prevent him from testifying. It is not disputed that the said witness was before the court on subpoena ad testificandum, but it must be realized that the witness was subpoenaed on the application of the appellants. He was not summoned by the tribunal in the exercise of their powers pursuant to paragraph 41, 5, and 6 of the First Schedule to the Electoral Act. He was therefore, for all intents and purposes, witness for the appellants. In that respect, his written statement or note was subject to the requirements of the law as stipulated by paragraph 4.5 of the First Schedule. Strict compliance with paragraph 4.5 of the First Schedule to the Electoral Act is mandatory. It's of such a nature that there is sanction in subparagraph 6 of paragraph 4. This point was also earlier made in petition 03. Also see the decision of PDP and Okabwe, and then Ogba and Vincent, Midira and Patricia Ete, Awoyemi, Lasun and Awoyemi. All these cases have their citation here, and they already referred to in our earlier 3. Okay. It is of interest that in all these cases, the earlier decisions of this court, Midira versus Patricia Ete and another, and Lasun versus Awoyemi, relied on strongly by Mr. Chris Uche, SAN, what the petitioners were cited and considered but departed from by this court. Quite remarkably too, in his book, Modern Nigerian Election Petitions and Appeals Law, published in November 2017, which book Chief Chris Uche, SAN, the lead counsel for petitioners hearing, wrote a glowing forward to. The learned author, Mr. Kelechi Peter Ikoroga, Esquire, had this to say at pages 134 to 140 while commenting on this same issue, the SR position of this court in Omidira and Ete, and then Lasu versus Awoyemi. There, Chief Uche, SAN, who is incidentally is present here, says, just like a petitioner in an election has 21 days from the date of the result of the petition to file his petition, otherwise such a petition becomes statute bar, there is also a time limit to the period within which a petitioner is to file a deposition or other document not filed along with the petition. Thus, all evidence required in proof of a case must, as a precondition to exercise jurisdiction, be brought within the stipulated time frame. That is to say, 21 days after the declaration of the result. The Supreme Court has consistently, in the long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. Thus, the efficacy of the decision of Omidira versus Ete, see also Lasu and Awoyemi, citation supplied, wherein the Court of Appeal held that it would be appropriate to meet the justice of the case for a tribunal to order the filing of witness depositions by subpoenaed witnesses outside the stipulated time frame has been watered down, in that all evidence required in proof of the case must be brought within stipulated time frame. See the case of Ogba and Vincent, where the Court of Appeal, Agim JCA, as it then was in lead judgment, held, I think that this court in Omidira and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or a court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election proceeding. Omidira's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006, the provisions in the first schedule thereto in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1(1) of Election Tribunal and Court Practice Direction 2006, and the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic approach of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the election tribunal and court practice directions as overriding the rules of court in election cases. In Oke versus Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The law has laid out strictissima juris in Oke and Mimiko is that a witness deposition that is not filed along with the petition within 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus: if there was evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition, even if it was being withheld by any person. There are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this, and the petitioner ought to have resorted to that procedure. Put this in italics, we have earlier mentioned it in 03. As earlier said, Chief Chris Uche SAN in his foreword to that book glowingly endorsed this author's position and even recommended it to judges like us in these words: the author has ably and remarkably sought to examine the legal framework of electoral legislation within the landscape of judicial decisions emanating from disputes arising from elections in the context of election litigation, from the preparation of the election itself through the pre-trial proceedings, the actual trial, the judgment and trial proceedings. This book truly stands out in the midst of several other books in this field. As an avid participant in electoral litigation, I wholeheartedly recommend this book to all, particularly to lawyers, judges, students of electoral laws, litigants, and as well as all stakeholders in the development of our constitutional democracy, unquote. I shall hold counsel to his words, not just because they are coming from him, but also because they are correct. Permit me to still say a word or two on petitioners' contention that Order 3 Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019 permitting parties to file witness deposition of a subpoenaed witness even after commencement of the action applies automatically to election petitions by virtue of paragraph 54 of the first schedule to the Electoral Act 2022. So witnesses' statement has said of their witnesses filed by them after hearing of the petition had long commenced wherein were in order, full stop. In the first place, paragraph 54 of the first schedule to the Electoral Act simply states, subject to the express provision of this Act, the practice and procedure of the tribunal or the court in relation to election petitions shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modification as may be necessary to render them applicable, having regard to the provisions of this Act, as if the petitioner and the respondent were respectfully the plaintiff and the defendant in an ordinary civil action. This provision clearly makes application of the civil procedure rules of the Federal High Court in election petitions subject to the express provisions of the Electoral Act. It is not the other way around of modifying provisions of the Act to agree with the rules of the Federal High Court as suggested by Petitioners' Counsel. That much, paragraph 54 further clarifies by stating that even where the Federal High Court rules are considered applicable, they shall only apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this Act, unquote. What all that means is that where there is express provision in the Act on a particular situation, such as it clearly is in paragraph 45B of the first schedule to the electoral act 2022, that says the election petition shall be accompanied by written statements on oath of witnesses, the provisions of the Federal High Court Civil Procedure Rules will not apply. Fortunately, there is again high authority in support of this position in the dictum of Muntaka Kumasi GSC in Wankwo versus Yaradua, citation supplied, where His Lordship, after producing paragraph 50 of the first schedule to the Electoral Act, now paragraph 54, had this to say. Say from the above, it is crystal clear that the provisions of the Federal High Court rules are subject to the provisions of the first schedule of the Electoral Act 26, and if there is any conflict between them, the provisions of the rules under the Electoral Act will prevail. It is where there is a lacuna in the provision of the rules provided in the Electoral Act 2006 that the provisions of Federal High Court rules will apply. I shall also add that the Parliament have expressly stated without dichotomy in paragraph 45B of the first schedule that to the Electoral Act that petitioners shall front-load witness statements of their witnesses along with their petitions. It is not within the province of the court to give that provision a different interpretation. It is also no moment that in the court's opinion, the say literal meaning of paragraph 45B of the first schedule to the Electoral Act 2022 seems harsh, may not meet the justice of the case, as is being suggested by the petitioners that subpoena is only issued to an unwilling witness, so it is not contemplated by paragraph 45B of the first schedule to the Electoral Act 2022 that a witness on subpoena should also depose to a witness statement before the subpoena to compel the attendance is served on him by the court. If anything, the argument rather brings to mind the very strong admonition of the British House of Lords of Lords, Lord Denning MRL in Newport Steels Limited versus SIRS, citation supplied, where the learned Lord Scaman in his speech said, but in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law, not to change it to meet the judge's idea of what justice requires. Interpretation does, of course, imply in the interpreter a power of choice where different constructions is possible. But our law requires that the judge chooses the construction which, in his judgment, best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Palatable statute may not be disregarded or rejected merely because it's unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits his idea of what justice requires in any case. That is the settled position of the law, even in this country. See Ndomaegba and Shukwogo, citation supplied, Aromolara versus Aguru, Coca-Cola Nigeria, Akinsanya, then Global Excellence, cited earlier, and Donald Duke. There, summarized aptly, wherein my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management through pre-hearing session as effectively as possible, to carefully plan the future course, and particularly its plenary hearing of every petition, so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Okogbu, and others, citations supplied, where my colleague Ahmadu JCA said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties, and open the floodgates for all kinds of abuses of the judicial process. Quote. I think the same point is also deducible from the following. In the dictum of Toby mentioned similar things in Buhari and INEC. And then Buhari and INEC also said a lot about that. We have mentioned it earlier. And then by rules of stare decisis, the decision in Oke and Mimiko and Ogba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor Rusek and ACB is there, and then ITPP Limited and UBN Limited. See the decision of Ogbuagu JSC. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW12 Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajagbona, PW15 Abidemi Joseph, PW16 Ms. Edosa Obosa, PW17 Ms. Aleria Ayuba, PW18 Ms. Sadia Mohamed Haruna, PW21 Mr. Samuel Odunta, the statistician, PW23 Janet Nuhu Turaki, PW24 Christopher Bulusado, PW25 Victoria Sani, PW26 Hitler Ewonu Mwala, forensic expert, and PW27 Mr. Mike Enaoroeba, legal practitioner, which did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act, is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. The further consequence of that decision is that, given the provision of paragraph 41 sub 3 of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It follows that all the evidence, including evidence in cross-examination and all documents, reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, PAR1C, PAR1D, PAR1E, and PAR1F, and PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD1A, PBD2A, PBD3, PBD4, PB1, PBE2, PBE3, PBE4, PBE5, PBE6, PBF1, PBF2, PBF3, and PBF4 coming from and tendered by the said petitioner's witnesses, namely, as I already listed, EW 12, 13, 14, 15, 16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned are incompetent and are hereby expunged from the records of this court. Other objections of respondents. That takes me to the other objections raised by the respondents to the admission of documents tendered by petitioners at the hearing, which objections they only gave notice that they will give reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to those objections. Now, before going into the objections, we deem it necessary to first dispose of the preliminary argument of counsel to petitioners that some of the documents objected to by respondents are electoral material certified by the first respondent INEC, which documents parties had agreed at the pre-hearing session that they will not object to. So respondents cannot resile from that agreement and raise objection as they are doing. They even cited Section 169 of the Evidence Act 2011 to say respondents are stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it. And it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See Shano and AfriBank and other authorities in that respect. As counsel, as ministers in the Temple of Justice are therefore within their right and in fact duty bound to draw court's attention to that fact, regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I would have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Answer to the first respondent in paragraphs 1.34 to 1.36 of first respondent's written address filed on 14th of July 2023. Second respondent at paragraph 3.13 of his 20th of July 2023 address, and third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023, all argue that that payment for certification is one condition precedent under Section 104 of the Evidence Act 2011 for certification of public documents. They said petitioners did not pay for certification of some INEC documents, specifically exhibits PAJ1, to PAJ37, PAJ38, PAJ39A to F, PAJ40, PAJ41 to PAJ and PAJ41 to PAJ7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAX13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any any evidence of payment of certification fees. Senate Council, all citing the cases of Tabik Investment and GTB, Jimon, Minister of Federal Capital, Emeka and Chuba Ikpeazu, argued that certification fees for the said documents having not been paid by the petitioners, documents remaining admissible and liable to be expunged from the records. Petitioners in response argued in paragraph 4.1 and paragraph 6.0 to 6.2, paragraph 2.1 to 3 of their response to second respondent and paragraph 2.16 to 2.7 of their response to third respondent that they actually paid certification fees to first respondent for their said documents and that they were issued receipts by the first respondent. Some of those receipts, they said, were attached to the documents themselves, while others were separately receipted for, including, in one instance, payment of 6,669,301 naira 25 kobo, and another for 150,967 naira 50 kobo. They argued that it was therefore unconscionable of first respondent who collected such huge sums of money from them to turn around and plead non-payment of certification fees. Then Senior Counsel on Petitioners' behalf also pleaded the Evidence Act's presumption of regularity of official acts and submitted that it was strange that a public institution like first respondent will come before a court of law to disown documents officially issued by it. In specific response to third respondent's argument, counsel to petitioners argued that Section 104(1) and 2 of the Evidence Act 2011 does not prescribe that the amount paid for certification must be reflected on the certified true copy of the document as part of the certification. So the argument of third respondent's counsel that because the certification of the said exhibits did not carry the amount paid for certification fees were not paid for is clearly erroneous. Now, Section 104 of the Evidence Act provides every public officer having custody of public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it, as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document, as required by subsection 2. Payment of certification fees is only a condition precedent to the certification. So it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama. And see also Uzoma and Sodike, ANPP and PDP, all these were made clear there, where it was held that certification in fee contained in separate document is sufficient. In this case, not only is there evidence of certification fee payment by petitioners first in the form of SBPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and attached to Exhibit PAF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made by the receipt number RRR 270-842-653235. and on INEC's receipt number 069727 of 25th of May 2023. It specifically states on its face thus: the sum of 6,696,301 naira 25 kobo only, being payment for CTC IPO electronic of a copy of data level number data level, although not very legible, with time, then stamp, event history, polling units of EC8As and S yet to be uploaded, from EC9 and other documents 2023 presidential election unquote. All that, in my opinion, is sufficient evidence of certification fee payment. Even more so, when the receipt indicates that the said payment also covers other documents outside those specifically mentioned therein. The burden had thus shifted to the first respondent, INEC, to show that the monies it received from petitioners for certification fee payment did not cover the documents they are now talking about, which documents INEC interestingly also certified. That burden INEC never discharged, especially when account is taken of the fact that it did not even give the amount assessed, if any, that petitioners were owing them for certification. By the provisions of Section 1041 of the Evidence Act, an applicant for certification of public document is only obliged to pay what is assessed by the public officer. What is more, the mere fact that respondents certified the said documents for petitioners, coupled with the evidence of certification fee payment by petitioners in Exhibits PD and PAF 4C, sufficiently triggers the provisions of Section 168(1) of the Evidence Act 2011 that says when any judicial act or official act is shown to have been done in a matter substantially regular, it is presumed that formal requisites for its validity were complied with. This ground of the objection is therefore overruled. Then on the issue of alleged engravement of certification, it was also argued by the respondents relying on Bello and Ahmed that certification of the same documents was done by a public officer of INEC by engravement of his name, official title, and date instead of subscription, so that also, he said, is invalidated the documents and rendered them inadmissible. I've carefully perused the said documents and verified that unlike Bello and Ahmed, the documents in issue here bear the longhand signature of the relevant certifying public officer of INEC. That, in our opinion, is substantial compliance with Section 104 of the Evidence Act and attracts the presumption of genuineness via Section 146 of the Evidence Act. First and second respondents in particular also argue that exhibits PAH1, PAH2, PAH3, and PAH4 tendered by PW21, Mr. Samuel Odunta, and exhibit PAR8 to F tendered by PW26, Mr. Hitler A1 Mwala, were made during pendency of this proceeding or in anticipation of it, and therefore inadmissible in evidence by virtue of Section 83(3) of the Evidence Act 2011. In their response, the petitioners argued that the said documents were made pursuant to the orders of this court, pursuant to Section 146(1) of the Electoral Act 2022, permitting them to inspect documents, so they were properly before the court. Much as I am not oblivious of our earlier ruling that these same documents coming from witnesses whose witness statements on oath were not front-loaded with the petition are incompetent and so already struck out, I am also of the opinion that the petitioners seem to 595 seem to completely misconceive the objection raised by the respondents, which is to the effect that the said documents, having been undeniably made during the pendency of this petition or in anticipation of it, are rendered inadmissible by the principal law guiding admissibility of evidence, the Evidence Act 2011, and Section 83 thereof, sub 3 thereof. It is therefore lame of the petitioners to find their breach or to found a breach of that provision on account of the orders of this court made pursuant to section 146 of 1 of the Electoral Act 2022, that they be allowed to inspect polling documents in the custody of INEC. In any case, section 146(1) of the Electoral Act 2022 merely states that an order for inspection of a polling document or any other document or packet in the custody of the Chief National Electoral Commissioner or any other officer of the Commission may be made by an election tribunal or a court of competent jurisdiction if it is satisfied that the order required is for the purpose of instituting, maintaining, or defending an election, unquote. This does not in any way give petitioners the leeway to adduce evidence in breach of section 83 sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of instituting or maintaining an election petition. Nothing in that provision allows a petitioner to file evidence, let alone the bulky expert reports as in exhibits PAH1 to 4, PAH1AF, PAR1A to F during the pendency of the petition. The whole idea behind section 83.3 of the Evidence Act 2011 is to eliminate the danger inherent in allowing a party to manufacture and bring in evidence specifically tailored in anticipation of a case, or was still produce such fresh evidence after the case had begun and parties had fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH1 to 4 and PAR1A to F, prepared and filed by experts long after pleadings in the petition had closed, when respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them in the said reports. I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as exhibits PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, C, D, and E, and F are without prejudice to our earlier decision that the incompetent is also rendered inadmissible in evidence by virtue of section 83 sub 3 of the Evidence Act 2022. Oh, sorry, Evidence Act 2011. Then the next one is inadmissibility of election documents tendered as exhibits by petitioners on grounds of absence of pleading to support them and consequential irrelevance to the petition. The respondents' argument here are given, so we'll now skip that to the resolution. We've seen that, and the resolution we have is, it appears clear to me that the respondent's objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and his agents wrongly and deliberately entered wrong scores results for the underlisted 22 states, namely Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Cross River Delta, Edo, Enugu, Gombe, Imo, Kaduna, Katsina, Kebbi, Niger, Osun, Taraba states. Pleadings, they said, of party is not read in that isolated manner to get at a party's complaint. Pleadings must be read holistically to get at the complaint in issue. If that is done as it should be done, the respondents would have come across where petitioners left no one in doubt that their complaint about the election is nationwide and not isolated to only some few states. That much is clear. First, from paragraph 107 of the petition, where petitioners averred that the petitioners shall give evidence to show that the election results as purportedly declared by first respondent in respect of each state of the Federation, including the Federal Capital Territory, the details of which are contained in the table below, and table was given, are wrong. Then they proceeded to list each of every state of the Federation. They also gave in the table wrong election figures declared by INEC for each state and FCT. Then in paragraph 147 of the same petition, they listed 60 different types of sets of documents they intended relying on to prove the said averment in paragraph 107 of the wrongness of the result declared by INEC for each state and the FCT, the presidential election. Among those documents listed by them are A, BVAS CTC reports, B, Forms EC8 series, then EC8A, EC8B, EC8C, EC8D, EC8DA, EC8E, that's a certificate of return received by petitioner's agents at the election. C, summary of the total registered voters on units basis. D, summary of PVCs collected on unit basis. E, data and event logs from all BVA's machines used in the election. And F, PVC collation records. These documents were specifically listed at paragraphs 147.1, then 6, 36, 37, 56, and 57 of the petition. These are the same averments to documents respondents are asserting were not pleaded by the petitioners and so irrelevant and inadmissible in evidence. They are indeed wrong. This ambit of the objection of respondents is therefore overruled and rejected. Then objection made by only the third respondent. The next set of objections to documents tendered by the petitioners were raised by only third respondent. I now proceed to consider them. Admissibility of video clips. Arguments were advanced there on, okay. Okay. Yes. So we said, I'm of the opinion that the contention is also misconceived, especially when regard is had to paragraphs 1, A, B, E, F, G of the certificate of authentication of the said video clips made by PW19 Dr. Ter. The authentication required by Section 84 of the Evidence Act in the circumstances the video clips in issue were made is statements assuring the court that they are in exact state, same state they were in the internet from where Dr. Ter, PW19, downloaded them to his laptop computer and subsequently to his flash drives before bringing them to this court. That much is evident in the contents of Dr. Ter's certificate in XBPAF 4B above. For the same reason, the argument of Dr. Ter is not the argument that Dr. Ter is not in position to answer questions on the said clips, and so his evidence on them is hearsay, is also non sequitur. Then there is also the issue of dumping of documents on court as ground for admissibility. With this one. Okay, that's part of the issue which will be considered deeply. Okay, you see, that is it. This is, okay. Some of them are listed. The simple and straightforward answer to this argument is that the issue of dumping of documents on court, which expression in any case suggests that the documents so dumped are already in evidence before the court, only goes to the weight to be attached to the documents by the court. On this reasoning, this ground of the objection is rejected and overruled. Then also there is allegation that some documents tendered were either made during pendency of this proceeding, I think I've seen that, and anticipation of it by interested parties. I think we've done a little consideration of this earlier. So we'll go to number 3. They said also that XB's PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, and up to PBF4, tendered by the petitioners through PW27, Michael Nauroeva, to show second respondent's non-qualification for the presidential election on grounds of his alleged conviction stroke fine in the United States of America, forgery of certificates, and dual citizenships are irrelevant to the proceeding and so inadmissible in evidence, petitioners having not pleaded necessary facts in their petition to support them. This also was looked at by us, and okay, I have already ruled while considering the preliminary objection of the respondents to the petition and replies of the petitioners that paragraph 146 of the petition, where the petitioners averred to non-qualification of second respondent for 2023 presidential election, was bereft of facts to sustain it. I also held that the fresh facts of a second respondent's conviction / fine by a district court in Illinois in United States, alleged forgery of documents and dual citizenship, all of which petitioners only introduced for the first time in their replies, were incompetent. They ran foul of both paragraphs 4.1d and paragraph 16.1b are incompetent, liable to be struck out, and were indeed struck out. I'm also aware that we have just a few seconds ago ruled here in this judgment that evidence of PW 27, though through whom they say the documents SB now impeached by third respondent were brought in, is incompetent for non-compliance with paragraph 4.5b of the first schedule to the Electoral Act. Those rulings constitute issue estupel, binding not only on the parties but on this court too, meaning further that this court cannot depart from them. See Francis Shano and Afri Bank, and also Lawal Daodo and Cardoso and Daniel and all that. Consequently, the objection of third respondent to the admissibility of this evidence earlier highlighted, the objection is hereby upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. The summary of all the foregoing is that, 1, the objection to the evidence adduced by PW 12, witness Eguma Friday, PW 13, Grace Timothy, PW 14, Grace Ajagbona. Okay. Well, you said all those ones we have mentioned and also recouched here, we say that the objection is upheld, and that evidence together with the documents, reports included, tendered by the same witnesses, are hereby expunged from the records of this court. See, it's there. Secondly, the objection of respondents to exhibits PAH1, PAH2, PAH3, PAH4 made by Mr. Samuel Odunton, PW21, and exhibits PAR1A to F made by Mr. Hitler Wanwala, PW26, is also further upheld, and the said documents already held incompetent and inadmissible by earlier rulings are again hereby pronounced inadmissible in evidence on this ground too. Then the third one now, exhibits, or the objection of third respondent to the admissibility of exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, PBD4, PBE1, up to PBF3, PBF4, tendered by PW27, Mr. Mike Enauroeba, is also upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Save for these ones mentioned above, all other objections of the respondents to documents tendered by the petitioners are overruled. Well, at this level, I hand over, like my brother said, to my leader to continue with the judgment. Thank you.
Well, I now consider the substantive matter, the substantive petition. I however wish to state that despite our conclusions above on the objections raised by respondents to documents tendered by the petitioners, I am still mandated to evaluate evidence adduced and consider merits of the petition. The only evidence I shall not revisit are exhibits PBD, PBD1A, PBD1C, 1B, 1C, 1D, 1 PBD1A, PBD2A, PBD3, PBD4, PBE1, 2, 3, 4, 5, 6, PBF 1, 2, 3, 4, and 4, relating to second respondent alleged non-qualification that were tendered by PW7 at 27. Mr. Mike Yenahoro Eba, the said documents, in our view, being bereft of pleadings to sustain them as a liberal stated earlier in this judgment. Coming to the hearing, the petitioners called a total of 27 witnesses and closed their case on 24th June 2023. The respondents opened their respective defenses starting from 3rd day of July 2023. The said respondent called one witness as one of its staff, RW1, and closed his case. The second respondent also tendered documents and called one witness, RW2. The third respondent did not call any witness but tendered documentary evidence. At the close of the case of the parties, the court ordered written addresses. The addresses were filed on schedule. In the final address for the first respondent filed on 14 July 2023, the learned leading senior counsel of first respondent, Mr. A.B. Mahmoud S.N., raised 4 issues as follows. 1. Whether, having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraphs 38 and 92 of the regulations and guidelines for the conduct of elections 2022, and totality of evidence adduced at the trial, the inability of the first respondent to transmit the polling unit results electronically in real time using the BVAS device to the RF portal constitutes non-compliance with the Electoral Act if such substantially affected the outcome of the presidential election held on 25th day of February 2023. 2. Whether there exists cogent and credible evidence of corrupt practice to warrant the nullification of the presidential election held on 25th day of February 2023. 3. Whether, going by the provisions of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended, the second respondent was at the time of the presidential election held on 25th day of February 2023 not qualified to contest the said election. 4. Whether upon proper construction of Section 134(2)(b of the Constitution of the Federal Republic of Nigeria 1999, the requirement that a candidate must score not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation as the Federal Capital Territory, Abuja, means that a successful candidate must specifically score at least 1/4 of the votes cast in the Federal Capital Territory, Abuja, in addition to 2/3 of all the states. The second respondent, through his counsel, Wale Ulani Pekun, SAN, filed his written address on 14 July 2023. He raised for determination 4 issues which were listed as follows. 1. Considering the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, as well as the admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and/or provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the peculiar circumstances of this petition, wherein the petitioners pleaded no fact in support of their allegation of non-qualification of the second respondent, whether the second respondent was or is not eminently qualified to contest the presidential election of 25th February 2023. 3. Upon a combined reading of Section 134 and 299, as well as other relevant provisions of the Constitution, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitution of the petition and the terse evidence adduced, whether this honorable court can accede to any of the reliefs being acclaimed by the petitioners. The third respondent, through her lead counsel, filed his final address on 14 June 2023. Similarly, 4 issues were generated for determination. 1. Whether, having regard to the relevant and admissible evidence led by the parties, the conduct of the present election held on 25th day of February 2023 was vitiated by non-compliance and corrupt practices that was substantial enough to direct or directly attributed to the second respondent as to have affected the outcome of the election and to justify nullification of the election in a manner envisaged by the applicable provisions of the Electoral Act 2022. 2. Whether the burden of proving that first petitioner and not second respondent scored majority of lawful votes cast and satisfied the constitutional requirement of having 1/4 of the votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 26 February 2023 has been discharged by the petitioner. 3. Whether, having regard to the issues joined and evidence led on the qualification of the second respondent to contest in the presidential election held on 26 February 2023, the petitioner has established that second respondent was not qualified to contest the presidential election as provided for in the Constitution and the Federal Republic of Nigeria, 1999, as altered. And 4. Whether, having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the reliefs sought in the petition at all, or that the petition ought to be dismissed in favor of the respondents. In response to the addresses filed by the first, second, and third respondents, the petitioners, through their leading counsel, Chief Chris Uche, SAN, filed their respective written addresses on 21st July, 22nd July, and 23rd July 2023. The petitioner's senior counsel filed separate written addresses in response to each of the first, second, and third respondent addresses. The issue for determination raised in the 3 written addresses filed by petitioners in response to each of the written addresses of each of the respondents are the same, and they are: 1. Whether the return of the second respondent in the election to the office of the President of the Federal Republic of Nigeria held on 25th day of February 2023 was not invalidated by reason of substantial non-compliance with the provisions of the Electoral Act 2022 on electronic transmission of results for collation and verification. 2. Whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory, Abuja, as required by the Constitution of the Federal Republic of Nigeria, 1999, as amended. 3. Whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from drug-related offense, his acquisition of the citizenship of a country other than Nigeria, and presenting a forged certificate to the first respondent. 4. Whether the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of the lawful votes cast in the election. A look at the issues formulated by the parties will show clearly that, though differently worded, they are similar in context and content. It is in the face of this that we choose the 4 issues formulated by the petitioners, albeit with necessary modifications to anchor the determination of this petition. The issues for determinations as modified are as follows. 1. Whether the return of the second respondent in the election to the office of the President of the Federal Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. 2. Whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory, Abuja. 3. Whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria as amended to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from the drug-related offense, his acquisition of the citizenship of a country other than Nigeria, and presenting a forged certificate to the first respondent. 4, whether the second respondent was duly elected by majority of the lawful votes cast in the election and the first respondent was right in returning him as duly elected. So we go to issue number 1, which is whether the return of the second respondent in the election to the office of President of the Federal Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. Yes, we have considered the submissions of counsel, which we have summarized here. So we'll just go straight to the resolution of that issue. This issue of non-compliance is directly standing on the first ground of this petition. Thus, by paragraph 16A of the petitioner stated that the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. By section 1341B of the Electoral, non-compliance with the Act is a ground for questioning or challenging an election. Primarily, the law is well settled that the results declared by ANEC first respondent in an election enjoy a presumption of legality. In other words, they are prima facie correct. Section 168 of the Evidence Act 2011, recently applied by the Supreme Court in Atuma and ANEC and APC, where in JSC held as follows. By virtue of section 168 sub 1 of the Evidence Act 2011, presumption of regularity inures in favor of judicial or official acts, including those carried out by ANEC. The exact words of the subsection are thus: when any judicial or official act is shown to have been done in a manner substantially regular, it is presumed that formal requisites for its validity were complied with. Fortunately for the appellant and first respondent, it is only a presumption which implies that it is rebuttable. Any person who questions the validity of an act in favor of which there is a presumption of regularity has a duty to rebut the presumption with cogent and credible evidence. A flimsy or half-hearted rebuttal will not suffice. Close of court. Any petitioner who complains that the result as declared is either wrong or not in compliance with the Electoral Act has the onus of proving the contrary. See Newsom Peterside. This case was relied upon by the Supreme Court in the case of Andrew and another versus ANEC, where the Supreme Court, per Onogen JSC, held as follows. Well, the term is far gone. We'll skip those petitions. When you get the judgment, you will see. Generally, it is the law that he who alleges must offer the requisite proof. The petitioners have the burden of proof, and they must succeed on the strength of their case as per their pleadings. The level of proof required is twofold. The first level is that there is non-compliance. The second level is to prove that the non-compliance substantially affected the result of the election. The learned senior counsel for the petitioners had in this petition argued that the burden of proof is on the person asserting the positive and not on the person asserting the negative. The petitioners, it appears from their position, tend to cross the line of its conception as to who has the burden of proof in adversarial system of justice in civil cases when the primary onus of proof is on the petitioner who makes all the claims against the respondent in this case. Well, we had started this case of Dashe and Druven by Ugo Jesse in the earlier petition just determined. That's petition number 3. Usually the burden of proof is the debt owed by the petitioners to the success of their petition. The burden of proof rests upon the party who substantially asserts the affirmative of the issue. It is fixed at the beginning of the trial by the state of the pleadings. If the party with the burden fails or could not discharge the burden, the decision must be against him. The case of Adegoke and Adibi Supra, relied upon by the petitioner, was cited in the recent case of Folarin and Augusto, where the Supreme Court by Okoro JSC held as follows. The quotation is there. It is therefore settled that the terms negative and affirmative are relative and not absolute. The burden of first proving existence or non-existence of an assertion or fact, whether positive or negative, lies on the party against whom judgment will be given if no evidence were produced on either side. In the instant case, it is fundamental to point out that from the pleadings, the allegation of non-compliance is generated by the petitioners. Under Section 1341 and 135 of the Electoral Act, the level of proof required for the success of is doubled. There must be proof of non-compliance and the further proof that the non-compliance affected substantially the result of the election. In the face of such an allegation of non-compliance, the court is enjoined by the law not to invalidate an election if it appears that the election was conducted substantially in accordance with the principles of the Electoral Act. All said and done, the petitioners have the primary burden of proving that there was non-compliance and that the non-compliance affects substantially the result of the election before the burden can shift to the respondents to establish that there was no substantial non-compliance with the Electoral Act in the conduct of the election. The petitioners have in their petition pleaded some of the facts relating to their complaint of non-compliance to the Electoral Act 2022. The key paragraphs of their petition in that regard are paragraphs 18, 22, 23, 25, 28, 29, 35, 36, 37, 38, 39, 40 to 44, 46, and 48 of the petition. The respondents joined issues with the petitioners in respect of this issue, and they all denied the facts pleaded by the petitioners. The denials of the first respondent in its reply are very significant. In paragraphs 17, 18, 19, 31, 32, 33, 34, 35, 36, and 37 of the first respondent reply to the petition, the first respondent is in great measure denied all the allegations of the petition in the petition. Since those paragraphs are direct and straight denial by the first respondent, the burden of proof remains on the petitioners to establish their claim as required by the law. Apart from the first respondent, who is the primary respondent, due to the fact that it is acts that are challenged in this petition, the second and third respondents, who are the beneficiaries of the declaration of the result, join issues with the petitioners. The second respondent, in its reply to the petition, countered all the petitioners pleaded in respect of the issue. Issue 1 with paragraph 6, 33, 56, and 57 thereof. The third respondent countered the petitioner's allegation with paragraph 26, 37, and 40 of its reply to the petition. Non-compliance in ordinary parlance means failure to or refusal to do something that you are officially or statutorily supposed to do. See Shulua and another versus To J.I. 13, Ojuku and Yaradua and Akirdu and Mimiko. The Electoral Act 2022, in an explicit manner, has laid out clearly grounds upon which an election can be questioned in Section 134 thereof. Then there is Section 135 of the Electoral Act, which looks like it provides to Section 134 for proper appreciation of the intendment of the law. Section 134 and 135 of the Electoral Act must be considered together. Well, an election may be, 1341 says, an election may be questioned on any of the following grounds. B of it says the election was invalid by reason of corrupt practices or non-compliance with the provisions of this act. Then 1351 says an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this act if it appears to the election tribunal or court that the election was conducted substantially in accordance with the principles of this act and that the non-compliance did not affect substantially the result of the election. This ground of non-compliance to the Electoral Act has been in all our electoral laws, even from when we had parliamentary system of government. The courts have, over the years, shed a lot of light on the requirement of the law in proving the allegation of non-compliance. A short chronicle of the decisions of our courts will throw more light on the evidential burden of proving non-compliance. For that purpose, we cited the cases of Bassi and Young, Awolowo and Shagari. We also cited the cases of Buhari and Anada versus Obasanjo and others, and CPC versus Buhari and others. So in all these decisions, the evidential burden of proof of non-compliance lies on the petitioner, who must first prove that there was non-compliance, and secondly, that the non-compliance has substantially affected the results being contested. Let me say that at the risk of sounding repetitive, that it is after the onus on the petitioner is discharged to the satisfaction of the court, that the onus will shift to the respondents to establish that the results were not affected. It follows for a fact too that for the petitioner, the allegation of non-compliance, they must plead clearly in their petition the non-compliance and call witnesses or place before the court cogent and credible evidence of such non-compliance. Need to place before the basis election, and that the impact votes are enough to invalidate the election. The petitioners, it must be underlined, of the petition that the petitioners had agents in all the polling units, centers, collection centers in all the states of the Federation and the Federal Capital Territory, as well as the National Collation Center. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicates of results from EC8A. The few called were state and national collation agents. Their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Bauchi State. In paragraphs 8 and 11 of his statement, he deposed that from his analysis, he discovered various forms of non-compliance and corrupt practice such as suppression of votes, manipulation of Vivas machines, manipulation of accreditation, intimidation